Senator Burris, the partisan gerrymander, the racial gerrymander cases, starting with Shaw, and there have been a series of them, essentially held that where you do not comply with the Gingles factors for creating a majority-minority district, if race is the predominant factor, then it violates the 14th Amendment Equal Protection Clause. The congressional districts in North Carolina, in Harris against McCrory, the legislative districts in North Carolina and Covington have both been held invalid on that principle, as were the legislative districts in Alabama, in the Alabama Independent Black Caucus case. So you've got to have the Gingles factors in order to create majority-minority districts. If you don't, you're violating the 14th Amendment. What the cases said was, and they allowed in those cases, the state of North Carolina to defend them by saying, oh no, race was not the predominant factor, politics were. But the court has not held and did not in those cases say that you could use political data to reapportion districts without violating other provisions of the Constitution. That issue is now being litigated in 3 cases. In Whitcomb, the Wisconsin case, the 3-judge court held the gerrymander of the state legislative districts unconstitutional under the 14th Amendment. In Maryland, there is a Democratic gerrymander case where the Democrats gerrymandered a single congressional district. That went to the Supreme Court of the United States on a motion to dismiss. I did an amicus brief for Common Cause. I am on the National Board of Common Cause. I've litigated these cases before. The Supreme Court in that case, in an opinion by Justice Scalia, held that the plaintiff in that case, who was a pro se litigant, had raised the issue under the First Amendment as to whether or not using political data, political belief, party affiliation, how people voted in past elections, was a violation of the First Amendment as a content-based form of discrimination, and held that that was not a frivolous claim, sent it back to the district court, which last summer, in a 3-judge opinion, ruled that it stated a claim under the First Amendment. There's a 3rd case pending in North Carolina in which I am lead counsel, challenging a Republican gerrymander of the congressional districts using political data. Those cases are all going to wind up in the Supreme Court in the next 18 months. We, Common Cause, support independent redistricting. And I can tell you more history than you want to know, but in California, that issue was fought tooth and nail by Common Cause and Arnold Schwarzenegger, the Republican governor, and was fought tooth and nail by Nancy Pelosi and the Democratic House and Senate delegation, both in state legislature, and was passed by the people. It is clear, if you look across the country, that the people would like to vote on the question of independent redistricting. In Arizona, it was put to a referendum, and the people passed it over the objections of the legislature, and the Supreme Court upheld it. Where the Supreme Court stands on it, I think, is relatively clear. In a recent opinion in the Arizona independent redistricting case, Justice Ginsburg said there is virtual universal agreement among the members of this court that partisan gerrymandering is antithetical to democratic principles. And she cites Justice Scalia's concurring opinion in Beef against Jubilee, in which he says he agreed with the dissenting justices that extreme partisan gerrymandering was unconstitutional. So states are going to be faced with 3 choices. You're going to end up litigating it case by case by case. You can come up with independent redistricting plans, which is the better solution, or do what Florida did, which through referendum, not through the legislature, they adopted a constitutional prohibition against the use of partisan data in independent redistricting. The 2 bills that are before you, the Independent Redistricting Commission is complicated, but it may be the best you can do to try to divorce politics. But the criteria the Supreme Court has said are legitimate to use are political subdivisions, trying to maintain them so far as you can, communities of interest, you must use population. Complies with the Voting Rights Act where compliance is required, which is only under the Gingell's factors. And geopolitical lines, you would not want a district to be on opposite sides of the Sierra Nevada mountains, for example. Those are typical examples. But voting history is wrong, and I can tell you something really worth reading is Justice Kennedy's concurring opinion in Beath against Juliera, in which he essentially says the lawyers in all those cases, you've been barking up the wrong constitutional tree. You should be bringing these cases under the First Amendment of the Constitution, because what is really involved in partisan gerrymandering is dividing districts based on people's political beliefs, their political affiliations, their voting histories, which is core First Amendment conduct. And the First Amendment law is
we're
very
at 6
clear.
minutes, and I apologize to the audience. I apologize to you. Obviously, your knowledge in this is deep, and I certainly do appreciate that, and I appreciate your thoughts. It's well thought out. So
We can have
thank you.
these private conversations if you want to have them. We've got more data than you want.
Sounds good. And I really appreciate that. Can you give me your background again? I didn't ask you to do that. I'm sorry.
I am a Georgia lawyer, admitted in 1959. I actually litigated the first reapportionment cases in Georgia. Westbury v. Sanders, I argued in the Supreme Court in 1963. I worked on a legislative reapportionment case, which was fought in the federal courts for 5 years. I actually represented the both Callaway forces in the governor's litigation in 1966. Unfortunately, I lost by 2-1 vote.
Right. So we have one question here for you, Mr. Bondurant, Senator Hill.
Thank you, sir, for coming and for your knowledge on this issue. Have you been working on this a long time, or is this new? Did you work on it years ago, or?
I've worked on it for a long time. The Common Cause has been sponsoring a gerrymander writing competition aimed at this issue for 4 years. There's a conference at Duke next week on that topic.
Were you close to any of the former governors? And what did they say when you asked them to do this?
As a matter of fact, Governor Perdue came out in favor of independent redistricting commissions, as a matter of fact. And the legislature appointed committee, I think, ended up filing no report.
It passed the state senate.
Sure appreciate that. We have another question, Senator Barbison.
Yes, if I may, I recall, I believe around 2000 when we were doing redistricting at the time, it was generally felt by members of the Senate at that time on our side of the aisle that the common knowledge was, whether it was actual federal court or Supreme Court law or not, that you could use political reasons to draw districts or data, but you couldn't use racial. So is that your recollection of it, as I understood, because it got thrown out, it got thrown in all kind of curves by the Supreme Court?
I think
Appeals
that,
Court.
candidly, I think that was common knowledge that was dead wrong.
Yes.
Bad political advice. And let me give you the analogy. In the racial gerrymander cases, they're essentially defending by saying it's an alibi defense. I didn't rob the bank based on race. I did it based on partisanship. I was robbing a different bank.
Because I didn't get away with it.
And candidly, the North Carolina General Assembly is proceeding on the assumption that partisan gerrymandering, egregious partisan gerrymandering, is constitutional. That's
Right.
going to be litigated in the court, and I will predict they will lose that issue.
And that's to be in the U.S. Supreme Court.
It will,
You'll be arguing that case?
yes.
Okay. Is there time on that?
We have a June trial date, starting June 26th. How fast the court will rule thereafter is anybody's guess. The Maryland case is proceeding. It does not have a trial date. The Wisconsin case, the state of Wisconsin filed its jurisdictional statement in the Supreme Court last week. And so whether the Supreme Court this term, before the end of the term, will take jurisdiction or not, remains to be seen. But my guess is that the court, if it's smart, will wait and consolidate all three of those cases. In the Reynolds v. Sims cases in the 60s, that's what they did. They held 4 state legislative cases and the congressional case, which I argued, and set them down for argument back to back on consecutive days.
Thank you very much. Appreciate that.